My name is Nick Carne. I'm the National Executive Officer for Wine Communicators of Australia, and it's my pleasure to be hosting today's webinar, Safety on a Page, the top 3 legal must-haves under Australian safety laws. I'd have to say it's not the sexiest topic we've ever done. We'd much rather be talking about branding or social media or export markets for Australian wine. But it's probably one of the most important we've done because issues such as these can seriously impact on a company's ability to make wine, to manage a brand and to develop markets. The wine industry is far from alone in this regard, but safety is one of those issues that tends to be front of mind when something bad hits the news services, then recedes to an administrative chore soon after. When I was talking with today's presenter, Will Snow, about this last week, he used the expression compliance fatigue, and I think that sums it up quite nicely. Will is a senior associate with Flinders, one of Australia's leading wine law firms, and their work is across all aspects of wine law, from branding to social media to export markets and to safety. They've been involved with the legal issues around incidents at wineries. They've seen the ups and downs of wineries trying to deal with problems, and I know for a fact they have acted in at least one of the cases Will is going to mention today. But these case studies, all well documented in the media, are not designed to point the finger or rake over old ground. Rather, they give a great example of how things can go wrong unexpectedly, and most particularly in terms of today's topic, what the regulations are that you are expected to meet or to have met. This webinar is part of a comprehensive annual series that WCA presents in line with its expanding role as a communications conduit for the industry, and our online program is growing. I'll talk about our next webinar at the end of today's. For now, I just need to remind everybody that webinars can be interactive sessions for all who wish to join in as well as to listen in. If you would like to ask a question or make a comment during the presentation, you have 3 options as set out on the screen now. You can use the comment box, you can tweet, or you can email. Now, Jen Barwick, who is WCA's Program Manager, is here with us, and she'll moderate your input, reply directly as appropriate, and send questions through to Will and me. If we don't get to your question during the presentation, we will get back to you later, and we will send all of you a copy of the slides as a PDF and a link to access the full recording of the session in your own time later. So if you know people who registered and couldn't get here, they can still get access to the webinar. Those of you who have taken part in our webinars before might be thinking that things look a little different, and you're right. We're working with a new webinar provider, Arcaden, for just the second time today, and the screen design is not quite the same as you might have been used to last year, but it works in very much the same way. And one final point to note, we have been having some problems with phone and internet lines here in Adelaide this morning for some unknown reason. We're normally very tech savvy here in Adelaide. Should something go wrong and a phone suddenly drop out, don't hang up or get out of the webinar. We'll be coming back to you very soon by another means. So that's enough of me. To get the webinar started, I'll hand over to Will Snow.
Thank you very much, Nick. My name is Will Snow. I'm a Senior Associate at Finlaysons. I work in workplace and safety law. So the work that I do in the winery industry is really aimed at both compliance, so ensuring that that wineries are meeting their safety obligations, as well as incident response. So that's really when something bad has happened, whether a near miss or a serious injury or a fatality, giving advice to wineries as to how to best manage their issues and their risks going forward. So today's topic is the top 3 legal must-haves under Australian safety laws, and this is really aimed at those written things that you need to have in place as a business to ensure compliance with the law. So I'll shortly be going to an agenda, but before I did that, and just to really put today's session in some context, I wanted to look at sort of recent significant fatalities and incidents in the wine industry in Australia. So the first one that I'll look at is Cullen Wines. So in Margaret River in 1998, a cellar hand very sadly passed away when he entered into a confined space. So what happened in this situation was that grapes were crushed into a 4,500 litre vat. They were then, the material then got lodged at the bottom of the vat. The cellar hand asked a colleague whether or not he should go into the top of the vat, and his colleague said, no, look, don't do it. It's too narrow to get in there. Unknown to his colleague, the cellar hand in fact did enter the top of the vat. There was also CO2 being pumped into the vat, and the person very sadly passed away inside the vat. Now that matter was the subject of a coronial inquiry. It wasn't the subject of a particular prosecution by the safety regulator in WA, but one of the key issues which came up in that particular matter was that the winery in question at the time didn't have a particular policy on entry into confined spaces, and nor did they have a particular SOP for the particular task that the employees were undertaking on the day as well. The next one that I want to look at is Drayton Wines in the Hunter. This involved some hot work, that is welding being done by a contractor on the outside, on the exterior of the winery. The welding was in fact being done on an ethanol tank, which, unknown to the contractor in question, had been filled with SVR ethanol some few days prior, about a third full. Now, the welding in connection with that highly inflammable substance resulted in a very large explosion and death to 2 individuals, as well as serious injuries to another individual. And that resulted in a prosecution and a coronial inquest with a fine of over $200,000 being made against Drayton Wines. And that was in fact a decision which was eventually handed down just in September of last year. The next one I want to look at is Wirra Wirra. This was an example where these new vats were being installed on an existing concrete slab. When the vats were, in fact, when the tanks rather on the tank farm were being filled up, the slab failed. They punctured through the existing slab. A worker was seriously injured, and some others were exposed to a significant risk of serious injury. And I guess one of the issues there that was raised in the prosecution decision was the importance of assessing the safety of structures when you are renovating or putting on new works onto an existing work. So far, those 3 critical issues. The first one, confined spaces. The second one, obviously, hot works and welding works is always going to create its own particular safety risks. And there, with that, with what happened at Wirra Wirra, obviously the importance of assessing safety when you're putting new works on top of existing works.
Well, what strikes me from those 3 is not only the great difference between the 3, but how specific the requirements are. A winery, in first blush wouldn't think of having a policy necessarily for entering confined spaces, or certainly a policy around hot welding. It's very specific stuff, isn't it? Yeah, it is. And so those particular safety risks, and I'll talk in a second about the safety laws, but all of those particular big ticket items, the Work Health and Safety Act and regulations, or the particular safety legislation in your state where you're listening from, all say particular things about those particular safety issues. The next one, Toorak Winery in the Riverina. This involved a potter tank having juice drained from it. The cellar hand in question opened up the bottom of the potter tank, and unexpectedly a large quantity of material came out into the potter bin, and the potter bin then moved, and then there was a pinch point between the potter bin and the platform, which trapped the worker concerned, and he died on site from his injuries. Very interesting decision in that this particular winery had some induction practices in place, some safety policies in place, but it was unknown to the winery that this particular potter bin, which could only be moved mechanically or via an engine system that it was coupled to. It was unknown when the injury and the incident actually took place, the fact that this potter bin could actually move unassisted if enough force was placed to it, and it didn't actually have a particular braking
or a locking mechanism in place, and this system of work was entirely redesigned by this particular winery immediately after this incident. So, and then the last one I want to briefly touch on is Carne Estates. This one is in SA, where there was an unguarded open throat auger, and a worker who was cleaning the auger at the time with pressurised grape juice fell into the hopper, and his leg was trapped in the auger, which was in fact rotating at the time, and he was later freed. He lost his leg, and a significant fine of $68,000 was imposed on the business in that situation. I'll come to Carne Estates in particular at the very end of this seminar, because the safety prosecution was quite critical of them as to how they dealt with their safety policies and their procedures. So those first sort of 5 particular incidents, which are all documented well in on OSLI, on the Legal Information Service, where you can find those cases, as well as in industry journals, quite prominent safety incidents where people have sadly either died or been seriously injured as a result of doing their work. And also, the other thing that I've also noticed as well from the timing of all those incidents is that they all occurred either before, during or shortly after harvest. So as a time when there's a greater volume of work being done, certainly the cases say that a serious incident or an injury will more likely than not happen during that very busy time as well. So that's, I guess, one of my own observations as well, looking at the timing of when people were injured. So what I want to talk about today, I want to give you a snapshot of the Work Health and Safety Act. I'll talk in a second about what I will be and won't be talking about in that. I want to look at, secondly, the sources of obligations that you will have under Work Health and Safety law. And then I also want to talk about this point here, policies and procedures. Now, Nick mentioned at the very start this issue of compliance fatigue, and I certainly have a number of clients who expressed their frustration with me personally about, you know, where is that sweet spot between being a compliant business and being a compliant winery and actually getting wine made and also making money. And that's something that I want to, I guess, really ask you all, as well as we go through this, you know, whether or not you in particular in your business have managed to get that balance right between compliance and productivity. So please send questions through to the webinar, and we can deal with those as we go through. I'll look at the 2 case studies in more depth, and they are the ones of Drayton Wines and also Carne Estates. And then lastly, I want to talk about 3 particular things which you can do immediately off the back of this webinar to ensure that your winery is getting toward a more compliant model as well. So firstly, a snapshot of the Work Health and Safety Act and where it applies. So I know that we have people who've dialed in across Australia, people in New South Wales, Victoria and SA, and possibly other areas. What I'm talking today about is the Work Health and Safety Act, which has been passed as law in those jurisdictions with a green tick. So Western Australia currently is a bit of an amber cross in that they're currently reviewing the legislation. More likely than not, they'll pass it later on this year, although it might be in a modified form. Now, Victoria has a cross on it, all the things that I'm going to be talking about today about obligations, about things which you need to consider with your wineries, apply equally to Victoria, even though the sections of the legislation that I have in my mind when I'm referring to particular obligations may not be the exact same things. Now, fortunately for Victoria, the model Work Health and Safety laws which are in place in those jurisdictions which had that green tick were adopted from your occupational health and safety law. So the critical obligations and looking about, say, what an officer needs to do and what a business needs to do, those things apply to all of us equally, no matter where we're looking from in Australia. But a lot of the some of the wording, though, where I'm talking about jurisdictions will really refer to those areas. So SA, the Northern Territory, New South Wales, Tassie and Queensland. So next, really looking at what the Work Health and Safety Act makes us do when we are running a winery. So firstly, you as a winery have a primary duty to ensure the safety of your workers while they are at work in your business. So worker is defined very broadly. A worker is definitely your casual and your full-time employees, whether or not they're working in the vineyard or in the winery or in cellar door or in your other retail operations which you might control. But it will also include any contractors that you have doing work for your winery. So to the extent that you engage contractors at particular times of year to do spraying or pruning, or contractors to assist in installing structures in your wineries, under the safety laws, they are also considered to be your workers. So you also have to ensure that person's safety so far as reasonably practicable. So that's a really important concept. You've got to ensure the safety of your workers who you engage to do work in your winery so far as reasonably practicable.
That's a really interesting and slightly scary concept in many ways, Will, because it begs the question of how much can you control what contractors do? And if you've brought contractors onto your premises to do work that you don't understand, how can you be responsible if they do the wrong thing?
Yeah, well, great point, Nick. So for example, you engage a contractor to install some new plant, which obviously you're not in the business of installing plant, you're in the business of making wine. Then certainly, while you have that obligation to ensure the safety of those workers, there's a real question as, well, what can you reasonably do to ensure that worker's safety? Now, for example, you may know in particular that they were going to access or they're going to put holes for a particular wall. You know, because it's your business, that there are asbestos-containing material within that wall. So in that situation, it is obviously within your control to say, look, before you go drilling holes into that wall, you need to know that, look, here's either our asbestos register, or we know or we think there might be some asbestos-containing material on that wall, or we know that there are electrical conduits going through that part of the wall. So if you're not making those safety issues, which you definitely know about, very clear to contractors that you're engaging, then you're not doing everything that you reasonably can. That said, if you're engaging an electrical contractor to do work, you do not have to know the Australian Standard on Wiring rules to ensure their safety. That's obviously an issue which is outside your expertise, but there are safety issues within your winery which you will know about and which you should get that person across. It also, one of the issues that immediately touches on as well is that when you are engaging contractors, the extent to which you need to induct that particular worker in your business, and so you have a set list of safety issues and procedures that bring to that person's attention and which they'll sign off on, and that they also know who they need to speak with in case an unforeseen safety issue arises. So that's really, I guess, again, one of those minimum things. So you have a definite and certain way of engaging contractors when they come on site to do work.
And so are you required to inform contractors about things that relate to the way the winery would work that your staff would already know?
Yes.
For example, that buggies may be coming through on a rail line any time, and if you hear a bell go, then just don't stand on the rail line. And your staff would know that, but you would be required to inform contractors.
Absolutely. Now, and that requirement to inform them really comes back to, you need to ensure their safety so far as reasonably practicable. Do they need to know about that? Well, yes, they do need to know about it, so you need to tell them. And the extent to which you can have that in a clean, 1 or 2 page document that sets out what those key risks are, that they can readily understand, that's going to help you discharge that obligation to those workers.
Because my next question was going to be, how would you ensure, for example, that if a contractor brought 3 people with him, that you told the contractor but he didn't pass it on to his 3 mates, and one of them got hit by the buggy? So is putting something in writing a useful idea?
Absolutely, it's a useful idea. And that's a really, what this session is really aimed at is really considering, not at all talking about compliance fatigue, and I'm not talking about having a 300-page safety manual, but what are those written documents which you can have in place which are going to ensure the safety of your workers? Yes.
And I think in some ways we possibly answered a question that someone's asked there, do we need a procedure or are we just teaching them to suck eggs? To a certain extent, I think what you are saying is we do need a procedure because there are so many areas in which you can be caught out.
And I think, and you may well be telling people to suck eggs, and you may well have a response from contractors of, look, don't tell me this, I know all this already. But for everyone who tells that to you, then there'll be someone else who'll say that anyway, but they actually haven't taken on the particular issues that are relevant to your winery, because while there may well be some standard things across the industry, there will be safety issues in your particular winery that are new or that have changed since that last person was there as well. So yes, there are often conversations where people say, look, stop telling me this stuff, I just want to get on with the work, but I really need to stress that as it's your business and you have safety obligations to those individuals, you need to do certain things from a documentary perspective that are going to cover you off if something goes wrong.
It's an interesting point. I mean, I'll let you go on, but another question just asked raises that question of, I can imagine there's situations where you have contractors who come every year, something has changed this year, you have to make a point that they understand that things are not quite the same.
Yeah. Things
are lower or higher. Yeah.
Okay. So, as a winery, you have a primary duty to ensure the safety of your workers, and you also have a duty to ensure the safety of other persons. So, definitely your workers, but this includes anyone who comes onto your winery. So, your customers who might be visiting your cellar doors, you have an express safety obligation to ensure their safety so far as reasonably practicable. So that raises very real questions about how you deal with guests onto your property, the extent to which your production areas are separated from your retail areas, and those very obvious safety risks and hazards such as water and dams for small children, and also the extent to which your machinery and other production areas are exposed to those people as well. So very real questions about how those strangers, those visitors, those customers can be safely excluded from those areas.
We've got some interesting response from the points we've just been raising. Someone asked, are there existing templates? Are there ideas that people could just doctor for their own needs to give to people? For example, here's the template of information I'm giving you as a contractor coming onto my site about the way this winery works and the things you need to know.
Oh, look, yes, there are. Certainly, there may well be industry associations, particularly the wine industry or more general, Chamber of Commerce associations who've got those sorts of safety documents. You can find them on the internet. Now, I'm not going to say how good or bad they're going to be. They're probably not going to be very good, but there's certainly documents out there which you can find and tailor according to your needs. There is no substitute, however, for perhaps looking at some of those case studies that I referred to in the beginning, and also as I'm going through this, making your own notes about particular safety issues which you need to be mindful of. But there's certainly documents out there. They're reasonably easily available. Some of them are free, some of them aren't. But keep your eyes peeled out there, and also as I go through these, make your own list of notes of issues which you can then take back to other managers, other directors, so you can have a discussion about this.
And possibly we at WCA might ask a couple of questions on your behalf, because people have raised the concept of the template, said, have a look what's around for the industry and get back to you.
Great. So the next obligation, so firstly, officers. Now, officers have a particular obligation under the safety laws to know and do certain things in relation to safety. So an officer of, let's say, a winery is going to be either a director of the particular business that owns the winery, or it'll be a person who has significant control and influence over the winery to affect the decisions of the winery. So people at a CEO or a general manager level will be considered to be officers of their particular winery, as well as obviously directors. So those persons who make or participate in making decisions that affect the whole or a substantial part of the business, they are officers, and they must know and do certain things in relation to safety. Firstly, if you're an officer, you need to know about your winery, its hazards and its risks. So how might people be hurt within your winery? How have they been hurt in the past, for example, is a good indicator of how they may be hurt in the future. About the risks about the winery. And you also need to know about safety laws. So to the extent to which anyone here on this webinar is someone who makes or participates in making decisions that affect the whole or a substantial part of the winery, and if you don't know anything at all about safety, or you feel, you feel anxious, or there are doubts in your areas about safety laws and what you need to do, then I'd really recommend that you turn your mind to these things, because the safety laws say that as an officer, you need to know about the safety laws. You need to know about the Work Health and Safety Act, or the regulations, or the particular regulations in your state or territory. You also need to do certain things as an officer. And that is to say, you need to ensure that there are resources and processes in place to manage risks. So that really comes down in a granular sense that if we are having contractors on site, do we have a particular way in which we are inducting those contractors so they can safely work in our winery? And you also need, the other thing that you need to do as well is to ensure that your safety processes, your documents and your procedures are in fact working. And so that comes down in particular to an audit process where on a regular basis you are considering, well, we have these safety documents, we have these safety policies, how do we know whether or not they're in fact working? So if you're an officer, you need to know and do certain things about safety.
I'm sure a lot of particularly smaller wineries are freaking out at this stage. It sounds onerous. Is it necessarily as onerous as it appears at first? It sounds like hours and hours of work and reams of paper.
No, it's not. It's not onerous, but the great difficulty is getting that balance between, yes, being compliant where your key risks are, and then also knowing that there are certain things you must have in place. And I'll come to those as we progress, Nick, and at the very end. But there is a bare minimum of safety issues which any winery, big or small, has to have in place, because the cases where things have gone wrong have shown that if those things were in place, then more likely than not, horrific injuries and fatalities may not necessarily have happened.
And it's not because they're a winery, it's because they're a business.
Absolutely. Now, this is the last sort of concept slide that I want to deal to in a bit of detail, but I really want to look at what the Work Health and Safety Act makes us do. So this is us here, a winery. We're a person who conducts a business or undertaking, so that's a business itself. It has to ensure the safety of its workers so far as reasonably practicable. And that is, doing that which is reasonably able to be done. So it's not wrapping everyone up in cotton wool. It's not, not doing work because there is some risk. It's about managing risks sensibly and trying and doing everything that you reasonably can within the resources and the materials and the expertise that you have. Now, if you have the management or control of a workplace as well, then you also need to ensure the safety of that workplace so far as reasonably practicable. So that comes down to ensuring that the entries and the exits from the workplace are free and they can be safely accessed and left. Also, if you supply, if you import or you manufacture plant substances or structures, you've also got to ensure that those plant substances or structures are as safe as reasonably practicable. So that's really going to be relevant for those of you on the webinar who are providers of infrastructure, plant and equipment to the wine industry. So that's really ensuring that the safety of your equipment is is safe so far as reasonably practicable. If you're an officer, you've got to exercise due diligence to ensure the safety of the workers engaged in your winery, and that again, that comes back to knowing and doing certain things about safety, and they're the things that I summarised in that slide beforehand. And then look, really importantly, again, we're looking at these duties that are related to a specific role. Workers and other persons, especially, and workers, both your employees and your contractors, they have an obligation under the safety laws to take reasonable care for their own safety and that of others. So, and that comes down to if someone isn't in fact doing work safely as you've directed them or as a particular policy says, then you are in a very strong position to say, look, you need to do the work safely, and if you refuse to do the work safely, that can be then the subject of disciplinary action or indeed perhaps termination of employment. And increasingly the Fair Work Commission has been supportive of employers who have needed to terminate employees' employment because they have refused to follow, in one case, safety policy with respect to wearing protective eye equipment. In another case, a safety policy with respect to working from heights. And in those cases, the Fair Work Commission has been very supportive of employers who have needed to terminate employees' employment where the safety obligation has been clear, they haven't met it, they may have been warned in the past, they've continued to breach that particular policy, and termination has then finally been needed. Now, work health and safety obligations, where are they drawn from? I've been talking before about the Work Health and Safety Act and the regulations. We can then imagine an inverted pyramid. You'll then have your policies and your standard operating procedures which will apply in your winery. And then I guess as a final layer, as a final overlay, you will have a contract, say your particular contracts with your employees may talk about safety obligations. As well, if you have contracts in place with your contractors, I would recommend that you draw your mind to what those particular contracts say about safety, and in particular, who does what in relation to safety for those particular contracts. Many contracts don't deal with safety. I think that safety can be very usefully dealt with in a contract. A couple of very useful things. Firstly, it's very relevant to define who is responsible for what under the contract. That is to say, who is installing what, where and when under the particular contract. Then it will be very clear from a legal sense who was obliged to ensure the safety of a particular job on a particular day. It's also very relevant in a contractual sense, if you do have a contract that gives you a right to perhaps exclude particular individuals from doing work if they're doing work unsafely, or at least gives you a right to raise safety as a topic of discussion, because as we were talking at the very start, you have those express safety obligations owed to workers. Sometimes you may wish to take it upon yourself to have a direct conversation about safety with a particular contractor, and you may wish to have a contractual right or any other right to exclude someone from working at your particular winery if they are not in fact working safely. So now talking about what those bare minimums are for a winery with respect to safety issues. So Nick, you raised beforehand, what can be done to ensure compliance. I want to talk about three particular things, and I'll summarise those again in a second. So firstly, the work health and safety legislation creates obligations for written safety documents. So to the extent to which your winery does not have any safety documentation at all, then that's an issue which you need to immediately address at the end of this webinar. So firstly, the Work Health and Safety Act says that the business must provide and maintain safe systems of work. Now, the easiest way of providing and maintaining a safe systems of work is to have standard operating procedures, to have job safety analysis or risk analysis provided in respect for particular tasks. So if you have high-risk tasks, say for example which involve entry into confined spaces, or which involved lengthened working at heights, or which involved welding or other hot work, then you need to have in place JSAs for those high-risk tasks, or indeed for other work which you're doing which involves inherent risks. Say for example, draining tanks, or moving other fluids, or indeed moving around other materials around the winery, to have SOPs in place. Also, the business and a winery must provide information or instruction to employees that's necessary to protect persons from risks. So definitely that means that you've got to have those procedures and policies in place, but also safety policies on general and specific risks. So there may be particular risks in place in your winery. There may indeed be risks in relation to working with asbestos, or other particular risks like working from heights. You need to have written documents about those things, and those sort of safety manuals and safety policies, you can find them on the internet, or you can purchase them, or you can find them through other sources. And I think that's a bit of a question I noticed for Nick that they'll come back to you about with some more information as well.
Yes, I noticed in some of the discussion references to Sawyer having some good documents in this area. So again, we might follow up on that and see what we can do. Because the obvious question becomes, an Act can tell you to have something, but who determines what's in it? Clearly, if you had a safety policy that says, be careful on ladders, lads, that wouldn't pass muster. But to what degree of detail you have to go into is obviously the tricky consideration.
Absolutely. And so I'll just skip to this next slide as well. In particular, you must, and this is a written document that you've got to have, a business must prepare an emergency plan with emergency procedures. So everyone knows what they have to do in the event of an emergency and how they evacuate. So that applies equally to your employees, to your workers, as well as to your customers who may be visiting your cellar door. So, and that really comes down to having, and so that's often interpreted in a way of, in this way, you have a clear map which is visible to anyone who might care to look for it, which provides a map of the layout, shows you where you are on the map and where you need to evacuate to in the event of an emergency. So the legislation says that, look, you have to have these written safety documentation. So jumping back again, safe systems of work. So you know there's a written way in which work is done, so you know it's going to be done safely every time, and having also written information and instruction necessary to protect persons from risks. So particular risks looking at hot work, confined spaces, working from heights, and those other particular safety risks as well as having a written emergency plan with emergency procedures. Okay, now, policies and procedures, are they a help or a hindrance? So this is often this question which comes and says, look, safety, too much information, it just gets in the way of making wine, it gets in the way of doing business, and I've made a decision that I don't want to have any safety policies at all, is a response which from time to time I hear from people in the industry. So this is really looking at this question, are policies and procedures a help or a hindrance? And this is forgetting about particular obligations under the Act. So firstly, yes, they can be a help in that if you have a written procedure on the way in which you're doing and way in which a task needs to be done safely, yes, it provides clear instruction to an employee or a worker, that is if they read it, which is often an issue in itself, but that's a separate topic. It'll also show that, yes, you are compliant with the legislation, and it's also going to be evidence that you have discharged your safety obligation. That is to say that you have done what you reasonably could have done to ensure someone's safety. So but then on the other hand, how can they be a hindrance? So policies and procedures can be a hindrance if it's jargon. If, look, anyone reading this document just doesn't know what it means, if they're overly wordy, or if it's written in words which which may not be suitable for your particular winery. So, and this is a really good point just to note. Say, for example, you do get, you buy a package of policies that, you know, as we're going through this session, you're thinking, oh, look, I want to review the ways in which we're managing these risks. I want to buy an off-the-shelf product. Just be really careful that it's written in a way in which you can clearly understand it and your workers can clearly understand it, because the extent to which it's overly wordy or there's jargon in there, it's not going to be an effective way of communicating a particular risk. They're also a hindrance, this next point, because they can get out of date very quickly. So your winery's risks, the layout of your winery, the machinery that your winery is using, the other plant and equipment that you're using changes, and you don't update your safety policies or your SOPs, they can very quickly get out of date, and then they're no longer helpful. And they're also a hindrance because they're also evidence as well. So the extent to which you have those policies and procedures in place and you're not meeting them, then that's immediately going to be relevant for, say, for example, a safety regulator who may ask for your policies and procedures, and they may well say, look, you have a policy and procedure here on hot work, you didn't follow it at all. And that will certainly be considered by the judge in the event of a serious injury or a fatality when it comes to deciding what the right penalty or the fine is from the outcome. So certainly, look, there's a balance between whether or not they are a help or a hindrance. But on all of these issues, I think those hindrance issues are really should be borne in mind. That is jargon. Are they clear to understand? And are they out of date? But I tell you what, if you don't have any of them, it will be the first question that is asked. So if a serious injury or a near miss or an otherwise notifiable incident occurs and you need to call your safety regulator and say, look, we've had an incident, then your safety regulator in whatever state or territory that you're at will come and inspect the site. One of the first questions will be, please provide us with copies of your policies, copies of your JSAs, copies of, you know, the training that was undertaken by the particular workers who work in the area, or indeed who may have been affected by the incident. That will be one of the first questions that have been asked, and it's often a question which I get involved in, you know, so half the work I do is involved in giving people advice about the compliance side of it. Then the other half of the work that I do that I get involved in is providing advice to businesses who are then dealing with the safety regulator and managing their interactions with the safety regulator. So all of those documents, they will ask them from you, and if you don't give them to the safety regulator, then they can compel them from you. So you must provide them to them, and what you've done will be assessed against what you said you'd do in those policies. And I think, you know, not having a policy in place is objectively much, much worse than having a policy in place and perhaps not being able to have followed it to the nth degree or followed it as closely as you would have liked.
And does good intent hold much sway with regulators? The fact, for example, that you have a suite of policies and yes, a couple have got about a little bit out of date but not for long, or more particularly, I think if you had policies in a whole lot of areas that were all really good but just never even thought about a confined space policy, for example, is the fact that you were generally a good citizen in what you attempt to do hold any sway, or is it quite simply you were supposed to have a policy A, you don't have one, you're gone?
Well, it's funny you say that, Nick, because all of these decisions, those decisions I looked at the very outset and that I'll come to in a second, they will involve guilty pleas. So by the time it hits the court, then all of those wineries have made the decision to plead guilty to the particular offence. And certainly when deciding the correct fine to be imposed, the courts do consider, yes, you know, they did have policies in place. Yes, they actively tried to do the best they could in safety. Yes, as soon as the event happened, they redesigned part of their winery or they took other steps. So all of those things are very much concerned and they're very much taken into account, and those things do lessen the severity of the fine that would be imposed. So near enough isn't really good enough, but those positive safety steps are favourably considered by the courts, yes. So the policies and procedures, they will be relevant if something happens. Now, I'm just going to give this quick slide here before we close on a couple of case studies. I hope that slide has sufficiently bamboozled all of you. Yes, hands up. Great, thanks, Nick. So this is, look, policies everywhere, policies. So this is the intranet site of a university, which shows all their particular policies and procedures in relation to, radioactive risks, operating an abattoir, where they store their rifles for the, agricultural research facility, the safety issues of their large spectron collider. So,
the top end of the range.
Yeah, look, and that really is a bit of a document nightmare, I would suggest, for most businesses. No doubt assessed to be suitable for this particular business or this higher education provider, which has got a range of different complicated risks. You don't need to have that. You don't need to have a million different documents that all refer to each other, because that's when I really would suggest that that would be a compliance nightmare to try for anyone to understand. So that's not what you want to have. But at the same time, there is a sweet spot which I'll shortly come to and I'll close on. So firstly, just these issues in a bit of in a bit of detail on the time we've got left. Drayton Wines in Pecolbin. So here there was welding work being done by a contractor, and unknown to the contractor, a few days before they were doing the welding on the particular tank, it was a third full of ethanol for fortifying wine. The contractor then commenced work on the outside of that welding of that tank. That wasn't work which was actually planned before the contractor was engaged into the work. It was work that he was directed to do while he was there to assist the efficiency of the winery. There was an explosion. This was a very, very sad case where there were the deaths of 2 individuals and a fine of over $200,000 was imposed against the winery, and they were fines imposed under the previous laws in New South Wales. Now, relevantly, the maximum fine that could have been imposed now under the current laws in New South Wales is now $3 million and or 5 years imprisonment for officers who were directly involved in the contravention or whose failure to exercise due diligence directly led to the injury or to the deaths as well. So really relevant to consider here is that there were no policy documents for this particular winery at the time. Various drafts had been prepared and also those drafts had been considered in fact by the board, but they had not yet been implemented. And there was criticism in the court decision from September last year about the fact that there were safety documents in draft form which were never in fact implemented as well. So there were no policy documents, there was no particular procedure on hot work, and there was also no evidence about how safety issues were managed by that contractor, and obviously a very unfortunate event where, unknown to the particular contractor, that particular tank was filled with ethanol. And obviously, had people known that, then then that welding work wouldn't have been done. There was just a very unfortunate breakdown in communication that occurred there. Carne Estates Wines, I talked about this one at the start. So here we had an unguarded auger. It's an unguarded open throat auger, which is in fact sold in that form by the supplier of the particular piece of plant. There was a migrant worker who was cleaning it. He slipped on top of the auger, on top of the hopper to which the auger was attached. Now, the evidence as well from the managing director of the winery was that he had told the worker not to clean from that particular position. However, the evidence of the worker was that he had seen this particular, he'd seen the winery owner up there himself, and that's why he thought it was safe to get up there. The auger was sadly operating when he fell into it. There was a prosecution, obviously, of Carne Estates wines. It was a fine of $68,000 imposed. Now, that was under the old legislation in SA. Again, the maximum fine now is $3 million or 5 years imprisonment. And again, in this particular situation, there were no documented safety policies or procedures at all as well. So that was a particular and discrete safety issue which was picked up in the decision, and that was especially criticised by the court. So two particular case studies, Drayton Wines and Carne Estates, where this issue of written documentation was came under special attention by the decision maker, by the court.
So I was interested, was any mention made in that case of the fact that the worker, irrespective of whether there was a written policy or procedure, had gone against what he had been told?
No, because what often happens in these situations is that, firstly, there were two particular things that were criticised. Firstly was that the auger was unguarded, and that as soon as this incident happened, the winery was able to install a mesh guarding on the auger at relatively little cost. So guarding of dangerous plant and equipment is the other high-risk issue, in particular for safety in wineries. And the other issue that came under attention was the fact there weren't any safety policies. Now, the fact that this particular issue was inherently unsafe, or that anyone listening might say, look, why on earth would you jump on top of this auger and put yourself in harm's way? That was not separately criticised. And indeed, when employees are injured, the inherent danger of a situation isn't something which is then the employee or the worker isn't criticised for that. What is always criticised in all of these cases are the systems in place and the way in which those inherent risks were not appropriately managed by the particular winery. Not to say, look, it was unguarded, why did you stick your leg in there? More that, it was unguarded, why wasn't there guarding on it? Why wasn't there a policy in place?
Okay.
Okay, so look, in closing, three particular themes, and these are, I guess, really top three legal compliance must-haves for everyone having to bear in mind, which comes back to the title of today's session. So firstly, you must have your general policy document in place. So having a safety policy that sets out your winery's position with respect to safety, which is a document that your workers, being your employees, and your contractors can easily have as your high-risk basic areas. So for your winery, that would be confined spaces, working from heights, hot work, and there may indeed be other ones which are just escaping my mind right now. Next one, standard operating procedures for hazardous machinery and plant. Every single one of those cases that I talked about at the very outset, and that I came in and then focused on with Drayton Wines and Carne Estates, not having SOPs in place for hazardous machinery and plant. So those areas where you are dealing with large volumes of material, heavy weights, working from heights, and there are those inherent dangers, have particular standard operating procedures which set out the safe way in which work can be done. And also reviewing those. Look, and another point that I get here, and I dealt with this matter for a client where they had a very dangerous piece of equipment which shredded up material. It wasn't in the wine industry, it was instead in heavy manufacturing. Now, what happened though, this particular piece of plant was guarded, but each year when they did a safety audit of the plant, they discovered that employees had removed the particular guarding because they preferred not to work with the guarding in place. So on 3 occasions, this guard was then found in other parts of the factory where these people were working, and every opportunity, they then put the guarding back on, and then again the guarding was removed. Now inevitably someone's leg got trapped in it and they got very severely injured. That was definitely considered by the court when they were prosecuted, but the court also said, look, if you did have a behavioural issue where employees preferred not to work with it, then you needed to investigate other guarding mechanisms which would have been easier for employees to work with. So if you're having criticism from workers about the safe way in which work is doing, have an open discussion about changing an SOP so that work can still be done safely, but it can be done in a different way, or in fact reflects the reality as to how the work is actually being done. But that is a very difficult issue that a lot of businesses have, that you have safety policies in place and people simply don't follow them. So then that comes down to auditing and also ensuring that the SOPs are useful documents which, and maybe they could be tailored to better reflect the reality of the situation. And then lastly, auditing, reviewing and revising your policies and procedures. So are they working? Do they need to be updated? Are they best practice? And certainly, I mean, there are certainly safety consultants out there who can assist you to meet those compliance steps, and certainly industry bodies who can review those issues for you. But these are not documents which you can simply write and then put in a drawer, because they will be immediately criticised, and no doubt your actual practice within 2 months, 6 months, 12 months will then deviate from what the written document actually says. So they're really the 3 things that I wanted to close on. There's a number of questions here. I'm just wondering if...
There's a question here I might raise with you, where we've got a couple of minutes to go. Were there any civil claims, e.g. negligence, arising from the winery injury incidents that you've outlined?
There may well have been. So what I'm really interested in, I mean, certainly there are civil claims that arise out of safety prosecutions. So all of these safety prosecutions are effectively criminal matters, which, you know, the state of South Australia or Victoria or New South Wales, by right of the Crown, issues criminal proceedings. Certainly, a lot of those matters, I'm not aware in particular from that person who asked that question whether or not those decisions have resulted in civil claims, but there are certainly numerous safety prosecutions which have then resulted in separate civil claims for damages. So you're right. So it's not really only an issue of safety prosecutions or the potential fine that may well arise, but if a safety incident does occur, you may well be looking at other significant areas of damages with your contracting parties, or with perhaps your workers in particular states and territories, if they have those rights to pursue you separately. Yes.
Well, that's great, thank you. We're nearly out of time. We've got a couple of other questions that we'll get back to people, as we always do, after the session. Hopefully later this year we'll be involving Will in another webinar session looking at crisis management. If you've got any thoughts on what you'd like to hear in such a session, please let us know. And as always, if you've got any thoughts on any webinars that you would like us to be running, please get in touch with us. We're always happy to try and tailor things to the needs of the industry. Our next webinar, which Jen will now flip to the slide for me, comes up in just a couple of weeks, May the 29th. We've moved our June one forward simply to take advantage of a specialist being in our midst to talk about social media laws in the United States. It's a fascinating area. If you thought that social media was the same around the world because social media goes around the world, wrong. And she'll have some really fascinating things to say. As always, this is free to all of our WCA members, so please log in for that. And finally, can I just say that as soon as this webinar ends, an exit survey will pop up on your screen. Please take a brief moment to fill it in. Along with feedback on this session, you can say whether you'd like to know more about the Finlaysons roadshows that are coming up later this year, which we're always keen to be a part of. Other than that, all I can do is thank Will for his time. I hope you found that all useful. We look forward to seeing you all at our next webinar. Thank you, Will.